all of us have to give up on our personal preferences. I never got to ask anybody to compromise core principles, but preferences must be yielded for the greater good. And
as part of the one big bloated backstab that Republicans have perpetrated against the Second Amendment community, they have dropped the NFA tax to $0, which leaves the door wide open for the next rabid anti-gun regime that comes into power to increase that tax to whatever they feel like. And I'm going to guess that they're probably not going to stop at $200. If they wanted to stick with some kind of logic, they would use the inflationary number, roughly $4,600, depending on how you do their math, of course, for the value of $200 in 1934. Something that was entirely avoidable, by the way, if the Republicans had done their job. But they could put it up to whatever they want, to $20,000 tax stamps. Thanks, Republicans. You did a great job, boys. The short-sightedness of this just amazes me, all because they wanted to meet some stupid deadline that they predestined, and in the process have left you and me hanging with our ass out, ready to get spanked by the next big government push that comes around the bend. The Republicans' chosen color is red, for redcoat. However, in the short term, we have possibly a marginal legal edge to challenge the National Firearms Act, and that has happened. Within hours of this thing being signed into law, a massive coalition of gun rights activists and organizations has filed a lawsuit against the government to challenge the National Firearms Act because the tax is no longer in effect. I'm going to take you to that lawsuit, give you a brief overview after we hear a quick word from today's sponsor. Today's video is brought to you by Medical Gear Outfitters. They are friends of mine and a sponsor of the channel for over a year now, and I thank them very much for being part of the mission here at the VSO Gun Channel. And I will put it to you this way. I have never fired my weapon in self-defense, fortunately. However, unfortunately, I have had to use my trauma kit in an uncomfortable number of instances. The most recent incident was literally a month ago. And without getting into a whole lot of details, easily avoidable situation, car accident. If you do not have a trauma kit in your house and in your vehicle, you are flat out wrong. And to help you get to the right place, there's a discount code available from Medical Gear Outfitters for all of you to take advantage of. I will have it listed in all the relevant places. Thank you to Medical Gear Outfitters for supporting the mission here at VSO Gun Channel. Now, let's get back to the video. In the United States Court for the Northern District of Texas, please, baby Jesus, let Reed O'Connor draw this case. Pretty please with sprinkles on top. Silencer Shop Foundation, Gun Owners of America, Firearms Regulatory Accountability Coalition, B&T USA, Palmetto State Armory, Silencer Co., Gun Owners Foundation, and Brady Wetz. Sues. Bureau of Alcohol, Tobacco, Firearms, and Explosives, United States Department of Justice, Pamela Bondi, Daniel Driscoll, both in their official capacities. You will notice that organizations like the National Rifle Association and Silencer Central are not part of this lawsuit, so that they can't dick it up this go around. I'm not going to read you the entire lawsuit. It's only 16 pages, but I'll give you the highlights. Enacted in 1934, the National Firearms Act is premised on Congress taxing power. The act imposed a $200 tax, approximately $5,000 in today's dollars, on manufacture and transfer of particular classes of firearms. The NFA's authors left no doubt that the NFA was an exercise of the taxing power, and the Supreme Court upheld it on that basis. This has been the uncontroversial understanding of courts and commentators for nearly a century. But the NFA no longer imposes any tax on the vast majority of firearms it purports to regulate. The One Big Bloated Backstab Act, which Congress and the President enacted on July 4, 2025, zeroes the manufacture and transfer tax on nearly all NFA-regulated firearms. That means the constitutional foundation on which the NFA rested has dissolved. The NFA cannot be upheld under any other Article 1 power with respect to the untaxed firearm. The act is now unconstitutional. If you skadoosh down to page 14, you'll see that the plaintiffs asked for two things. Count one, declaratory judgment that the NFA's regulation and transfer requirements exceed Congress's Article 1 enumerated powers with respect to untaxed firearms. NFA's registration, manufacture, and transfer requirements pertaining to untaxed firearms exceed Congress's enumerated powers. These requirements were enacted and sustained as an exercise of Congress's taxing power. Silencers, short-barreled rifles, short-barreled shotguns, and the NFA's any other weapons category are now untaxed, yet the registration and transfer requirements persists. Plaintiffs are injured by the NFA's unconstitutional requirements. Plaintiffs are entitled to a declaration that the NFA's registration and transfer requirements exceed Congress's enumerated powers. Count two, injunctive relief against federal officials from implementing or enforcing NFA with respect to untaxed firearms. Plaintiffs are entitled to a permanent injunction against defendants from implementing or otherwise enforcing any part of the NFA that pertains to untaxed firearms. Prayer for relief. A, declare that the NFA's registration and transfer requirements pertaining to the untaxed firearms exceed Congress's enumerated powers. B, enjoin defendants and their employees, agents, successors, or any other person acting in concert with them from implementing, enforcing, or otherwise enacting under the authority of the NFA with respect to untaxed firearms. C, award plaintiffs reasonable costs. D, grant plaintiffs and all such other and further relief to which they are justly entitled at law and in equity. So to translate this for you, the tax has gone away on SBRs, SBSs, silencers, and AOWs. However, the registration requirement that was predicated on the paying of the tax has gone away. No longer constitutional, can't do it anymore. Court, we want that in writing, that that's the way that this works. And then two, we want you to bar any agent of the government from enforcing the National Firearms Act and its provisions against the American people, specifically to the plaintiffs, but it'll create two classes of folks, and the Supreme Court really hates that sort of stuff. So there's a chance there, I suppose, if you believe that the Supreme Court is actually going to do anything about this. Now, the thing that is interesting here is they only asked for permanent injunctive relief. They did not ask for a preliminary injunction, which is oftentimes the case with a lot of Second Amendment litigation. They will ask for a preliminary injunction, which basically says, hey, you can't enforce this while we're litigating it. And they have chosen not to do that this time because Gun Owners of America et al. In here recognizes that the time is short on this one. We've only got a couple of years to get this litigation done. The last time we had a major lawsuit against the government like this, it took many years and millions of dollars worth of litigation to get it done. This is why the Republicans screwed up so bad and leaving us out to dry on this one. We have very little time to get this done in the scheme and scope of constitutional litigation, and we have to move fast. We don't have time to dick around with trying to keep the government from enforcing it in the short term because the tax is zeroed out. We have to get this all the way up through the courts as quickly as possible, and we're going to forego the preliminary injunction. Is basically what this thing says, right? They only asked for declared unconstitutional and prevent them from enforcing it against the American people. So to be real with you, we got our butts kicked. If I want to be gracious, I'll call the big bloated backstab bill a draw. And what a draw means is that the first salvo or the first interaction, the first contact that was made did not have a definitive winner. And the winner of that exchange is to be determined by the next action. This is where we're left. So we can sit here and cry in our beer over it, I suppose. I'm not saying that we forgive. We absolutely hold those representatives responsible for what they did to us. They should be out of office, and you should not show up for them in the coming midterm elections. But in the interim, while we wait for our vengeance, this is the way. I will keep you appraised as it develops. Now, if the administration, Donald Trump et al., Pam Bondi, Driscoll, all those folks, if they wanted to show Second Amendment support, if they actually wanted to solidify that, they keep talking a good game and their actions don't really show it, but if they wanted to do it, then here's your chance, Mr. President and Madam Attorney General and Mr. Director. When that lawsuit gets to court, you show up and say, Your Honor, the right. We do not challenge. All eyes on the executive branch, I suppose. Thank you for tuning into the VSO Gun Channel. And if you have the stomach to celebrate the 4th of July this weekend, then have a great time. I, for one, will not be participating because freedom lost. And we have Republicans to thank for it.
All of us have to give up on our personal preferences. I never got to ask anybody to compromise core principles, but preferences must be yielded for the greater good. And
just remember that. The Second Amendment is a preference. Remember that.